you have to know, at least in your mind, a general meaning of the word preponderance of evidence. You don't have to define that in detail, but do not forget certain words when you define it. Do not forget, let us say, superior weight of evidence, because that is what the examiner will be looking for. Superior weight of evidence. Now, in a criminal case, you don't have to memorize section 2 on proof beyond reasonable doubt, but you have to use the words, and the words moral certainty must appear in your definition, because that is what the bar examiner will be looking for. Okay? Now, is there any other difference between evidentiary rules in civil cases and evidentiary rules in criminal cases? Oh yes, there could be. Let's think about it, okay? Oh, this one. Could you go to section 27 of Rule 130? You notice something? An offer of compromise in a civil case does not result into an admission of liability, but an offer of compromise in a criminal case may be received in evidence as implied admission of guilt. They're different. Remember, the general rule, all rules of evidence are applicable to all proceedings, but we're talking about these exceptions. Is there any other difference between a civil proceeding evidence and criminal proceeding evidence? Oh yes, one is constitutional. A defendant in a civil case cannot say he is presumed not to be liable. There is no such thing as presumption of innocence of a defendant in a civil case. But does the accused enjoy the presumption of innocence? Oh yes, in the Constitution. And in procedure, you will find that presumption in Rule 131 in Section 3, Letter A. Okay? Is there any other one? Look at the word confession. Somewhere below 33-34, Rule 130. The word confession is an admission of guilt. In other words, the word confession is more associated with a criminal case rather than a civil case. In a civil case, you simply use the generic term admission. You do not make a confession in a civil case. The word confession is in a criminal case. It's associated with a criminal case. Any other difference na medyo nadaanan natin? Well, in a civil case, evidence of moral character can be presented even by the plaintiff or by the defendant, provided it is relevant. But evidence of the bad moral character of the accused cannot be presented by the prosecution unless in rebuttal. In a civil case, there's no problem. There is no such thing as unless in rebuttal. Anything more? The survivorship disqualification rule, Section 23 of Rule 130. The claim there is against the estate. Get my point? So, that provision applies to a civil case or a special proceeding. It does not apply to a criminal case because the plaintiff files a suit against the estate. That's a civil case. It's a claim against the estate. Is there any other rule? In pre-trial, is there any evidentiary rule in a criminal case which does not apply to a civil case? Oh, there is. Section 2 of Rule 118 is for a criminal case, and that is an evidentiary principle. Whenever the accused makes an admission, it must be set forth in writing, it must be signed by the accused, it must be signed by the counsel, otherwise it will not be admissible against him. Oh, that is evidence. That's Section 2 of Rule 118. Do you have that equivalent provision in Rule 18 in the civil case? There is none. One more, let's try to think about it. Demurrer to evidence. Could you find a distinction between the rules in criminal cases and civil cases and demurrer to evidence? There are distinctions. In a criminal case, the court can demur to the evidence by dismissing the case, as long as it gives the prosecution an opportunity to be heard. Now, where did we get that? Section 23, Rule 119. Could you look at it, by the way? The court may even make a demurrer on its own, but it's called dismissal. Remember, a demurrer to evidence is a dismissal. Did you see that? The court cannot do that in a civil case in Rule 33. If you read Rule 33, there is no authority for the court to make a demurrer on its own initiative. Oh, there are other differences, but they are more for civil procedure, like this. In a civil case, there is no need to file a motion for leave to file a demurrer. But in a criminal case, there are two kinds and two ways of filing a demurrer. It may be with leave of court, without leave of court. Oh, there are more. Let me give you an example. Did you see Section 24 of Rule 130? Did you see there the privileged communications of physicians? Read it for a while. In other words, it does not apply to both cases. It cannot apply to a criminal case. It applies to more of a civil case. Did you say civil? Not criminal. In other words, these are exceptions to the rule that all rules of evidence are applicable to all proceedings. That's not true.